It finally happened. Judge Caldwell lost all patience, and the marshals did not hesitate. What you are about to see is unprecedented. A federal judge pushed past his limit and ordered the immediate removal of a defendant from his courtroom. No warnings, no second chances, marshals moving in before the words finished leaving his mouth. And then, the shock no one expected. Bail denied on the spot. This was not theater. This was not showing off. This was a federal judge saying in front of cameras and a packed courtroom that enough is enough. When a sitting judge looks at armed federal officers and says, "Remove him now, you know something serious just happened. Here is exactly what happened and why everyone is talking about it." So what triggered this extraordinary moment in his courtroom? On what was supposed to be a routine pre-trial hearing, Judge Caldwell saw something that broke his famous patience. A patience that had lasted through decades on the federal bench. This was not just another courtroom outburst caught on camera. This was a federal judge making a careful decision to use his full power in real time with the entire legal world watching. The defendant, who had already pushed limits in earlier appearances, crossed a line that Judge Caldwell made clear would never be crossed again. What happened in those explosive 90 seconds is now being studied by legal experts across the country. Former prosecutors are calling it a lesson in judicial authority. Defense attorneys are calling it terrifying. And I have the courtroom accounts, the legal filings, and expert analysis right here. But here's the thing. What caused the removal is only part of the story. The bail denial that followed is where this becomes truly unprecedented. Because when a federal judge takes away your freedom in the middle of a hearing with marshals already standing next to you, your entire legal plan just fell apart. Let me show you exactly what they are trying to spin. Here's what actually happened inside that courtroom. The moment everyone clicked to see. The hearing began at 10:17 a.m. According to people in the courtroom, the defendant entered showing clear disrespect, refusing to acknowledge the judge, whispering loudly to his legal team, and at one point appearing to laugh during routine statements. This is it. This is the moment that changed everything. Judge Caldwell, after handling early matters, turned to the issue of the defendant's compliance with pretrial conditions. That is when the defendant interrupted, cutting off the judge in the middle of a sentence. According to reporters there, the defendant said, "This court has no authority over me. I do not recognize this proceeding." Judge Caldwell paused. The courtroom went silent. He gave the defendant one chance, just one, and calmly said, "You will behave with respect in this court, or there will be immediate consequences." The defendant's response was to turn toward the audience and make a dismissive gesture toward the judge. That was the trigger. Judge Caldwell's voice, according to many witnesses, changed instantly, not louder, but colder. He said, "Marshals, remove this individual from my courtroom immediately. We are done." 2 U.S. Marshals near the side entrance moved without delay. The defendant barely had time to react before he was physically escorted toward the holding area. But here's the key part. Judge Caldwell was not finished. As the marshals moved in, the judge continued, "Let the record show that the defendant has shown intentional contempt for this court's authority. Based on this behavior, combined with documented violations of pretrial release conditions, the court is revoking bail effective immediately." Bail was taken away in real time as the defendant was being removed. Legal experts, who later reviewed the transcript, stressed that this was not emotional, it was planned. Judge Caldwell pointed to specific violations, missed check-ins with pretrial services, claimed contact with witnesses despite a no-contact order, and social media posts that appeared to threaten court officers. The defendant reportedly missed 3 scheduled check-ins during the past month. Court records show that pretrial services filed 2 formal notices of noncompliance, both discussed in earlier hearings with warnings. Those warnings ended the moment the defendant interrupted the judge. The bail revocation order, filed within an hour, used language rarely seen in federal court. Judge Caldwell wrote, "The defendant has shown a basic refusal to follow release conditions and has shown contempt for the judicial process itself. Continued freedom poses an unacceptable risk to the fairness of these proceedings." And it gets worse. According to sources close to the case, investigators had been building a case for bail revocation for weeks. The defendant's social media activity, despite being ordered to limit public statements, included posts that prosecutors argued were meant to scare witnesses. One post, according to court filings, referred to people believed to be cooperating witnesses by their initials, using language the government described as hidden threats. Judge Caldwell addressed this directly in his written order. The defendant's public messages show not just poor judgment, but a planned effort to weaken the justice system. Former federal prosecutor Marcus Webb told legal observers that this level of detail shows the judge had been waiting for the right moment. This was not a sudden reaction. The revocation order was ready. The defendant's behavior in the courtroom simply gave the final reason. The defendant is now being held without bail while waiting for trial, a status that is extremely hard to change in federal court. His legal team has 24 hours to file an emergency appeal. Subscribe right now because what happens next in this case could change how federal judges deal with defiant defendants across the country. I am covering every update as it happens, and you will want to be here for all of it. Now, you have seen what happened, but here is how we got here, and it makes Judge Caldwell's decision even more justified. This clash did not come out of nowhere. Tension had been building for months, driven by the defendant's habit of pushing limits, testing the judge's patience, and treating court as a stage instead of a legal process. Everything changed during a hearing 3 months ago when the defendant first openly challenged Judge Caldwell's authority. According to transcripts from that hearing, the defendant questioned whether the judge had the power to set any pretrial conditions at all, a claim with no legal basis, which the judge rejected but noted for the record. At that time, Judge Caldwell said, "This court's patience should not be mistaken for weakness. I am allowing flexibility. That flexibility can be taken away." The defendant seemed to take that as an empty warning. Over the next weeks, pretrial services recorded a pattern of small rule breaking. The defendant checked in late, sometimes by hours, sometimes by days. He gave incomplete information about where he was. He submitted forms missing signatures. Each problem alone might seem small, but federal judges look for patterns. At a hearing 6 weeks before the removal, Judge Caldwell addressed these issues directly. He said, according to the transcript, "I am giving you a formal warning. One more documented violation and I will consider revoking your bail." The defendant's lawyer told the court compliance would improve. It did not. 2 weeks later, pretrial services flagged the social media posts. The posts did not openly threaten anyone, but they referred to the case in ways that pushed or crossed the protective order. When prosecutors filed a formal request to revoke bail, they included screenshots, dates, and expert opinions arguing the posts were meant to intimidate witnesses. The hearing where the marshals stepped in was scheduled specifically to deal with that request. Judge Caldwell had already reviewed the evidence. He had already spoken with court security. The marshals were placed where they were because the judge expected trouble. What the defendant did not understand and what his legal team failed to make clear was that he was walking into a courtroom where every outcome had been planned for. When he interrupted the judge, he was not testing someone unprepared. He was triggering a response designed for that exact moment. Smash the like button if you are following this, because knowing how we got here is key to understanding what comes next. Drop a like so more people see this breakdown. I read every comment and want your opinion. The most shocking moment came when the marshal stood on both sides of the defendant, and he still did not stop. According to witnesses, even as officers moved in, the defendant kept talking. He reportedly said something like, "You cannot silence me. Everyone watching knows what this is." Judge Caldwell's reply was immediate and strong. He said, for the record, "Let the transcript show that the defendant continues to disrupt these proceedings even as he is being lawfully removed. This behavior will be considered during sentencing if there is a conviction." The courtroom went completely quiet. Reporters said the feeling was intense, a mix of shock and, for some, relief. One court sketch artist with 23 years of experience said afterward, "I have never seen anything like it." The judge's voice never rose, but the power was absolute. As the defendant was taken through the side door, he tried to turn back toward the audience. Marshals physically turned him away. The door shut. Judge Caldwell, without hesitating, spoke to the remaining lawyers. "We will take a 15-minute recess. When we return, we will continue with the government's other motions." And just like that, it was over. But it really was not. Because what happened in those 90 seconds is now being talked about in federal courts across America. This was a message, and every defendant watching understood it. Stay with me because the impact of this is huge. But first, leave a comment right now. Did you expect this? Do you think Judge Caldwell was right to act this way? I read every comment and want your view. This is not the first time a federal judge has ordered marshals to remove a defiant defendant, but the details here make it unique. Think about the Chicago 7 trial in 1969. Judge Julius Hoffman, dealing with constant disruptions from defendant Bobby Seale, ordered him tied and gagged in court. That choice was later criticized, and Seale's conviction was overturned. The difference here is that Judge Caldwell did not try to keep a disruptive defendant in the room. He removed him immediately and revoked bail, stopping future disruptions completely. Then there was the 1988 case of tax protester Irwin Schiff, who kept interrupting judges with claims that income tax was unconstitutional. He was removed from several courtrooms and later banned from filing legal papers on his own. But even Schiff was not held without bail just for courtroom conduct. What makes Judge Caldwell's decision different and what legal experts are studying closely is the mix of instant removal and bail revocation at the same time. Professor Sarah Chen from Georgetown Law explained, Usually these are separate steps. You remove someone for contempt, then later decide on bail. Judge Caldwell combined both, and he had the proof to support it. That proof matters, because his order did not rely only on the outburst. It listed weeks of violations, creating a record that supported immediate detention. This is how experienced federal judges work. They do not act on emotion. They prepare even against defendants in their own courtrooms. The pattern is clear. When defendants keep testing authority, the consequences stack up. Here, those consequences arrived all at once, on camera, in front of the legal world, in a moment that will be studied for years. Judge Caldwell did not just remove one person. He set an example that courts across the country are already discussing. Legal experts call this a turning point for judicial authority in federal court. Marcus Webb, a former federal prosecutor with 18 years of experience, said Judge Caldwell's actions were classic but taken to another level. He explained, every first-year prosecutor learns to build a record before making a big move. Judge Caldwell clearly had weeks of evidence ready. The courtroom clash was just the last step. Doing both the removal and bail revocation in real time shows total confidence in the law. Webb added that the defendant's legal team now faces an almost impossible appeal. They would have to claim the judge had no good reason, but the record shows warnings, violations, and conduct no reasonable judge would accept. Constitutional law professor David Armitage from Harvard stressed the wider message. This shows that federal courts are not stages for political shows. Armitage said, Judge Caldwell made it clear the courtroom belongs to the court. Defendants who forget that take a serious risk. Defendants do not have the right to disrupt proceedings. A criminal defense lawyer speaking privately gave a cautious view. Defense lawyers are watching closely. Some worry judges could feel encouraged to act more harshly with less evidence. Judge Caldwell had a strong record. Not every judge will. Still, even defense-focused experts admitted the defendant's actions were extreme. Former public defender Natalie Reyes, now a commentator, said, there is strong advocacy and then there is self-destruction. This defendant chose self-destruction. No lawyer could save him in that moment. Reyes noted the defendant's lawyer looked clearly upset during the removal. You could see it happen. The lawyer knew what was coming and could not stop it. This is a nightmare for any defense lawyer. What makes this case especially important, according to analysts, is how clear the record is. Judge Caldwell's written order, filed within an hour, is 11 pages long. It lists every missed check-in, every risky social media post, every warning from earlier hearings. Former appellate judge Patricia Hammond said the order was not written in an hour. It was prepared. He was ready for this moment. That is the difference between a reactive judge and a strategic one. If this breakdown is helpful, smash the like button now. It really helps more people see this. The algorithm rewards engagement, and your like helps spread the word. So what does this mean going forward? First, the defendant will stay in custody until trial, which could be months away. Federal detention before trial is very hard to overturn. His lawyers would need to show the judge abused his power, which is unlikely given the record, or that something important has changed. But here's the problem. The defendant's courtroom behavior is now part of the official record forever. Any appeals court will read the transcript and see the earlier violations. The defense will argue that revoking bail for courtroom behavior is too harsh. Prosecutors will argue there is a clear pattern showing the defendant cannot be trusted to follow rules. Second, this changes how every federal defendant acts in court. Defense lawyers across the country are already sending new guidance to clients. The message is simple. Federal judges have power and they will use it. Courtroom defiance will not be allowed. Sources say public defender offices are updating training materials to cover situations like this. Lawyers are being told to clearly warn clients and document those warnings. That way, if a client acts out, responsibility is clear. Third, this sets an example for combined removal and bail revocation orders. Before this, most lawyers thought these would happen separately. Judge Caldwell showed they can happen together when the record supports it. Legal experts are debating whether this expands judicial power or simply shows how it already worked. Professor Chen said the power was always there. Judge Caldwell just showed what it looks like when used firmly. The impact on defendants with pre-trial release conditions is big. Even small violations now build a record that can be used instantly if behavior in court gets worse. Fourth, this changes the thinking for defendants who plan to be disruptive. Some, especially those with political goals, have used court as a way to make statements and get attention. Judge Caldwell's response shows the danger. You may get your moment, but you may also spend months in jail while your lawyers try to fix the damage. The message to future defendants is clear. The courtroom is not your stage. The judge controls it completely. And if you forget that, you will be reminded in the most serious way. Every defendant waiting for trial in federal court just saw what happens when you go too far. Many are rethinking their plans right now. Then the defendant's team made it worse. Within hours of the removal, statements from his supporters appeared that were highly inflammatory. Instead of admitting the violations, allies attacked Judge Caldwell personally. Social media accounts tied to the defendant's circle called the judge a tyrant and accused him of political persecution. One post, now saved for possible court review, said, "This so-called judge just showed America what real fascism looks like." That post has already been flagged for prosecutors. The defendant's official legal team responded more carefully, but only slightly. Their statement said they were disappointed and would appeal right away. What it did not do was take any responsibility for the violations. Here's the problem with that response. It is likely to make things worse. When your client Ms. Checkins may have broken a no-contact order, posted threatening content, and interrupted a federal judge, attacking the judge is not a smart move. Legal analyst Rachel Torres said the response actually helps the government. It proves Judge Caldwell's point that the defendant and his supporters do not respect the court's authority. Every attack on the judge shows why bail should not be granted. Torres added that prosecutors are likely watching these statements closely. If any cross into threats or witness intimidation, they could lead to new charges. The defendant is already in custody, but his supporters are still creating legal problems for him. When your defense attacks the judge instead of answering the evidence, you have already lost. The 11-page bail order speaks for itself. It lists dates, times, screenshots, and direct quotes. It notes earlier warnings on the record. Against that, name-calling online does nothing except risk more charges. The defendant's team has 48 hours to file a formal appeal. Experts say it has little chance of success. But beyond the legal details, this is about something bigger. It is about the rule of law. It is about whether courts can work when defendants treat them like stages for performance instead of places that demand respect. Every day, federal judges handle cases with people who think rules do not apply to them. Some believe being loud replaces legal arguments. Some think defiance will overpower authority. Judge Caldwell proved otherwise. When he said, "Marshals, remove him immediately," and they moved without delay, he showed every defendant that courtrooms have rules, judges have power, and the system will push back harder when tested. If disruption went unpunished, the entire justice system would weaken. What happened was not just about one person. It was about every future case, every judge facing defiance, every courtroom where someone tests the rules. Judge Caldwell answered clearly, the rules apply. The authority is real, and if you forget that, you will learn the lesson in handcuffs. Subscribe for continued coverage of this case. The appeal is coming, the trial is coming, and I am tracking every update. Hit subscribe and the notification bell now. Here's where things stand. The defendant is in federal custody at a detention facility while waiting for trial. His lawyers have confirmed they will file an emergency appeal within 24 hours. Sources say the appeal will argue that revoking bail mainly for courtroom behavior is too harsh. Experts doubt it will work because of the long record of violations. Judge Caldwell has made no public statements beyond his written order. Sources say he is treating this as routine despite the attention. He is not giving interviews. He is simply doing his job. Prosecutors may file more motions based on statements made after the arrest and the social media activity of supporters. The trial date is still set for 3 months from now. With the defendant in custody, his ability to help prepare his defense changes a lot. Defense lawyers have 48 hours to request a hearing about detention conditions. Watch closely when the appeal is filed, likely soon. The arguments will show their strategy. Also watch the government's response. If new charges are added, this case grows even bigger. The next 72 hours will decide whether this stays a bail issue or becomes much more. The stakes are huge. The evidence is clear. A federal judge told the world his courtroom will not be a circus and proved it with action. What happens next will shape how courts deal with defiant defendants for years. The appeal, the trial, the precedent all come from this one moment. This is not just another legal story. It is about whether the rule of law still matters when tested. Judge Caldwell answered that. The defendant is in custody. The message is clear. Subscribe and hit the notification bell. I will cover every step as this case moves forward. I will see you in the next one.